Hello to one and all present over here. My name is Lakshaya and I'm an intern at LEXIS and Co. I'm starting in third year in New Law College, Pune, and the topic for today is Limited Liability Partnership Amendment Bill 2021. The Limited Liability Partnership was introduced in the Upper House on July 30, 2021. The bill seeks to amend Limited Liability Partnership Act 2008, which has been pending since 2008. LLP is an alternative to the corporate body form of the traditional partnership firms. Under LLP, a partner's liability is limited to their investment in the business. The bill converts certain offences into civil defaults and overall changes the natures of punishment for these offences. The key features of this bill are as follows. The government is trying to ease out a business which is carried and encourages more startups. To encourage more businesses, they want to incorporate LLPs. They want the conversion of partnership firms into LLPs. They remove the fear of criminal prosecution from non-substantive minor and procedural omissions and commissions in the normal course of their business transaction. The primary objective of decriminalization is to remove the criminality of offence from business laws, wherein no malified intentions are involved. With the offences being decriminalized, they mainly revolve around the manner of operation of an LLP. The violation of requirement mentioned below can cause the business to be fined anywhere between 2,000 rupees to 5 lakh rupees. The requirements have been decriminalized and charge a monetary penalty only. They are as follows. If there is a change in the partners of an LLP, there will be certain prosecution. Change of registered office will come to in a certain prosecution. Filing of statement of account and solvency and annual return may or may not result in a motion. Reconstruction or merging of an LLP as well as agreement between an LLP and its creditors or partners. Coming to the change in name of an LLP, this says that change in name of an LLP may be directed by the central government if they deem fit on certain grounds like undesirable name or identical name or a trademark pending registration. Failing to comply with such direction is a ground for fine ranging from 10,000 rupees to 5 lakh rupees. The bill removes some of these grounds and instead of imposing the fine allows the government to just allot a new name to the LLP instead. The Act further defines if the partners of any LLP carry out an activity which will defraud the creditors or any other activity which may be deemed fraudulent. Every person who is party to it knowingly will have to face imprisonment of up to 2 years and fine ranging from 50,000 rupees to 5 lakh rupees. They will increase the fine from 2 years to 5 years. Central government may compound an offence which is only punishable via fine. The amount being imposed here will be the maximum amount stated in the Act. The bill amends this right to a regional director or someone of a higher rank to compound such offences. If an offence was compounded by an LLP or its partners, then a similar one cannot be compounded for a term of 3 years. Establishing special courts for speedy trials has also been ensured under this Act by the central government. The special court will be consistent of a sessions judge and a judicial magistrate. They will be appointed in the concurrence of a Chief Justice of High Court. There is introduction of a few new concepts here. They are as follows. Small LLP. In keeping the concept of small companies, it is planned to create a new type of LLP called small LLP. Small LLPs would face some less compliance requirements, a lower fee or additional cost, and fewer penalties in the case of default. As a result, a cheaper cost of compliance would encourage unincorporated micro and small partnership to convert into an LLP and reap the benefits. Previously, small LLPs were defined as those having a contribution of less than or equal to 25 lakhs as an annual revenue of less than 40 lakhs. The proposed change would result in the 25 lakhs will be converted into 5 crores and the turnover would be considered 50 crores. Non-convertible debentures. It is planned to allow LLPs to obtain capital by issuing fully secured non-convertible debentures to investors who are regulated by SEBI or RBI. This will aid in the development of the debt market and capitalization of LLPs. Another major point of this bill is the reduction in additional fees. It is proposed to amend Section 69 of the Act with a view to reduce the additional fees of Rs 100 per day, which is presently applicable for delayed filing of forms documents. A lower extra cost is projected to encourage LLPs to file records and return more quickly, resulting in an updated register that can be used for proper regulation and policy making. To conclude, the government is bridging the gap between corporations and limited liability partnerships, making LLPs significantly more appealing and simple to manage so that many of today's entrepreneurs that chose the LLP model may benefit from the same simplicity of doing business. My name is Lakshaya and I hope you enjoyed the video today. Thank you.